As a follow-up to our webinar, DOL announces new overtime rules, what you need to know and do to comply. We have Ashley Kaplan, Senior Employment Law Attorney, here to answer some of your pressing questions about the new overtime rule. Ashley, thank you for being here with us. I'll let you get started on the questions from our webinar attendees.
Okay, thanks, Stephanie. Okay, so we literally got hundreds of questions that came through, so I did try to go through them and scan through them, and I picked out questions that came up over and over again, and then also I'm trying to respond to the questions that I think are more general and that apply to most of you. We apologize if we weren't able to get to your questions. Some of them were really, really specific, but hopefully the ones we picked out will answer most of your questions. So the first one is, are the managerial duties still in place for an employee to be exempt, or is it strictly salary threshold? And the answer is, the only thing that changed with the new rule is the salary threshold when it comes to the exemption test. The duties test did not change. So the question about did the managerial duties, are they still in place? Yes, absolutely. And I assume you're talking about the executive exemption. That's typically the one where people would refer to it as managerial duties. So the test for executive exemption, we also got a lot of questions for that, if I could just go over that test. And that's sort of a segue with this first question. The new test is the employee has to be paid on a salary basis and in an amount of at least $9.13 per week. That's the part that changed. The rest of the test is still in place, which requires the employee's primary duty has to be management of the employer's enterprise or a customarily recognized department or subdivision of the business. Next, the employee has to customarily and regularly direct the work of 2 or more other employees. And that's really key. That's, this has to be someone who is managing or supervising at least 2 or more employees full-time. It could be 4 part-time employees, but it has to add up to 2 or more full-time employees. And then finally, part of the test is that the employee has to have authority to hire or fire other employees, or the employee's suggestions and recommendations as to hiring, firing, and advancement, or other changes in an employee status have to be given particular weight. So this is typically the exemption that works for managers, but all of those must apply. It's not just the salary threshold. Okay, another question that came up a few times. Does this new rule apply to company owners? If a company is co-owned and one of the owners receives less than the minimum $47,500 salary, does this apply to them? And this is part of the FLSA that has not changed. This was has been in place for a while, but there is a special exemption that applies to business owners, and that is still in place. And under this exemption, it's not about the minimum salary threshold. The test is simply that the individual has to own at least a bona fide 20% equity interest in the business, and the person has to be actively engaged in the management of the business. So if those 2 things are true, if you can establish those 2 things, it's okay that the owner does not receive the new minimum salary. That's not part of the test. Okay, another question, we've got dozens of questions about nonprofits. Does this new rule apply to nonprofits? The new rule doesn't specifically apply or not apply to nonprofits. Nothing in the rule mentions nonprofits or exempts nonprofits. So we default to the FLSA as it always has been. And the FLSA does apply to nonprofits. There are no special exceptions. So yes, this new rule applies as it does to all businesses and enterprises. It also applies to nonprofits. A couple of things to point out, though, with nonprofits. Just the regular test for enterprise coverage for any business, which applies to nonprofits as well, is that the business needs to have annual sales or business of at least $500,000. And when you're talking about a nonprofit, when you're counting the sales or revenue that goes toward this $500,000 threshold, you only have to count the activities that are performed for a business purpose. So it doesn't apply to the nonprofit's charitable activities, activities that are not competitive with other businesses. So, for example, income that is derived from contributions or membership fees or dues or any kind of donations that are used for charitable activities are not counted toward that threshold. So it is possible, just in the general definition of enterprise coverage, that a nonprofit, like any other business, might not meet that threshold. However, I have to, this is really important. Even if a business doesn't meet, or a nonprofit doesn't meet that $500,000 threshold, there's a separate test for whether your employees are covered by these FLSA requirements. And even if your business or nonprofit isn't covered, employees almost always are, because for individual employee coverage, all you have to show is that the employee is involved in some kind of interstate commerce. And interstate commerce is very broadly defined. It could even mean, using credit cards or making phone calls from another state, anything that crosses state lines. If any goods or materials that are used by the nonprofit come in from other states, like I said, if the employee is conducting any kind of work that involves phone calls or credit cards, they're going to be covered. So in most cases, you are going to be covered just because your employees are. And then finally, I just wanted to point out, even if you're a nonprofit and you don't meet the $500,000 a year threshold, there are certain types of nonprofits that are covered no matter what. The Department of Labor has actually listed them out, and those are hospitals, schools and preschools, government agencies, and businesses providing medical or nursing care for residents. So those are covered by the FLSA no matter what. Okay, the next question is, can employees still be non-exempt salaried? And this is something I touched on in the presentation, and the answer is yes. I mean, you can, if you don't qualify for an exemption, if an employee doesn't qualify for an exemption, you can still pay that employee a salary. However, because they're not exempt, they are still covered by the FLSA's minimum wage, overtime, and record-keeping requirements. So you can pay them a fixed salary, but they have to keep records of their hours worked. You have to make sure they're at least getting the minimum wage for all hours worked. And if they ever do work over 40 hours, you have to pay them overtime at the 1.5 times their regular rate. You can prohibit overtime and pay them a salary, and that seems pretty simple, but you still have to pay attention to the record keeping, and if they do go over 40, you still have to pay overtime. There's another arrangement that I mentioned in the presentation where you can also pay a non-exempt employee a salary, and it's the fluctuating rate overtime plan. And this is where, if you're going to pay them a salary, knowing that they work a lot of overtime, this is an arrangement where you can pay a guaranteed minimum salary every week, and when they work overtime, the overtime is calculated at a reduced overtime rate where you only owe half time, not 1.5 time. There are a lot of complexities around this. You have to guarantee the minimum salary every week, even if they don't work the full 40 hours. It works for a lot of companies, but I would say to work with an employment attorney if you're going to try to use the fluctuating rate overtime plan, because it is a little complicated. Okay, this is one we got a lot of. What category would commissioned employees fall into, exempt or non-exempt? And the answer depends. When it comes to commissioned employees, the first, the two exemptions that come to mind that would, typically apply are the outside sales exemption and the inside commissioned salesperson exemption. So I'm going to talk a little bit about those two. Otherwise, even if someone is commissioned, they still need to meet an exemption test. So if they're commissioned, we talked about how under the new rule, up to 10% to reach the salary threshold can come from things like commissions. They still have to meet that salary threshold where they are getting a fixed guaranteed salary. It can't be all about commission, and they still have to meet a job duties test. But I'm going to talk about the tests for outside sales and inside commission sales because they're a little unique. And we also got a lot of questions, a lot of people asking if I would spend more time on those two. So for outside sales, this one is really interesting because this is one that does not require a minimum salary at all. The new $9.13 a week does not apply. But in order to qualify for this exemption, the employee has to truly be an outside salesperson. So that means that the majority of their work, their primary duty, has to be making sales, and it needs to be away from the employer's place of business. So that doesn't mean, from a home office or any kind of fixed office. It means that the employee has to be at the client's business, customarily and regularly. That's the standard. They have to be engaged away from any fixed office, your office or their home office. They need to be actually performing their job at your customers' or clients' places of business. And if their primary duty is, making sales or getting, orders or contracts, and they're also working in the client's place of business, then they can be considered exempt from overtime, and you don't even have to meet a minimum salary requirement. The other sales exemption that I mentioned is the inside commissioned sales exemption. And for this one to apply, this is only a partial exemption. It is an overtime exemption, but the employee would still have to keep records. They're not exempt from record keeping. So for this to apply, the employee has to be employed by a retail establishment as defined by the FLSA. And just basically that means that 75% of the business's gross annual dollar volume of sales or services has to be provided to an end user. It can't be for resale. So the first requirement is that the employee has to be in a retail establishment. The second requirement is that the employee has to receive more than half of his or her total compensation from commissions. So if they're only making some commissions, but the majority of their pay is either hourly or salary or whatever, this isn't going to work. They have to be predominantly their pay has to come from commissions. And number three, you have to ensure that these employees receive at least 1.5 times the minimum wage for all hours worked. So that's where the record keeping comes into play. They're still required to keep records because you have to make sure that they're being paid at least 1.5 the minimum wage rate for all hours of work. So it's considered a partial exemption. Okay, next question. Can someone be hourly exempt, paid per shift hours for total hours a day, but exempt from the labor laws? I think I see where the person is going with this, and the answer is no, not really. From the way that I'm understanding the question, in order to be exempt, there are really like 3 things that apply for all the exemptions. The first one is the minimum salary requirement, the new $9.13 a week. The second one is what kicks in here. The second one is the person has to be paid on a salary basis or a fee basis. But a salary basis means they have to get a guaranteed fixed amount for a period representative of 7 consecutive days. So they need to have a fixed weekly salary that does not fluctuate. It cannot be reduced based on quantity or quality of work. So it is not tied to hours in a day or quantity of work performed. This arrangement, the way that the question is worded, hourly exempt, paid per their shift hours, means that they're not being paid on a salary basis. So they wouldn't be meeting that second part of the exemption test. So the 3 elements for any exemption, except for a couple of the exceptions like outside sales, are the minimum salary of $9.13 a week, number 2, a salary basis of pay, and number 3, the job duties test of the specific exemption, like the executive exemption job duties, administrative exemption job duties, etc. Next question. Is the effective date December 1st or the payroll period that includes December 1st? So for some, it might be effective in November, correct? The answer is the effective date is absolutely December 1st. However, if your payroll period crosses over, so where December 1st falls in the middle of your payroll period, you need to make sure that you're in complete compliance as of December 1st. So that might mean you need to go ahead and make these changes before December 1st if your payroll period covers dates that are both before and after December 1st. If there's some way where you can, even within the same payroll period, have 2 different classifications, I think that would be really complicated, but The point is that it has to be switched over by December 1st. So if that means you have to do it a little bit early to include it in your pay period, if your pay period starts in November, then you need to go ahead and do that. Okay, the next question. What about those making less than $50,000 a year, but they're only required to work less than 40 hours a week? And that's a really good question, and it came up a lot. In the case of an employee that doesn't even work overtime at all, you still have to make sure, you still need to look at whether they qualify for an exemption or not. Because if they don't qualify for an exemption, even if they don't work overtime, you're still required to treat them as a non-exempt employee, which means they have to, the record-keeping requirements would still apply to them, and minimum wage and overtime. So even if they're not working overtime and you prohibit overtime, if they don't meet an exemption test, and they don't have the 913 a week or the 47,476 a year, they would be considered non-exempt, and they would need to keep records of all hours worked. And if they do work over 40 in a work week, you would need to pay them time and a half for the overtime. Next question is kind of similar. It's really the inverse. What if an employee makes $60,000 salary a year and works over 40 hours a week? Are you in compliance? So I think what the question is if they're making $60,000 a year and they work overtime over 40, are you okay paying them a salary without overtime? And the answer is no, not necessarily. So remember, the salary threshold is only one of the three requirements, the three criteria that you have to establish for an exemption. Even if an employee is making, $160,000 a year, if they don't meet an exemption test with a job duties test, they are not exempt, and they are entitled to overtime. And in those cases, your overtime premium is going to be really high because the overtime is based on the salary divided by the hours worked, and that becomes your regular rate, and then to multiply that by times and a half, the higher the pay, the higher the overtime exposure. So it's really important that everyone understand this. It's not just about that magic number, that new 47,476 a year. Just because they're over that number doesn't make it okay to go ahead and pay a salary without overtime. They also have to meet a job duties test or whatever the full criteria are for an exemption test. Next question. Can we convert employees who don't qualify for exempt status to independent contractors instead of making them non-exempt and paying overtime? This is a major danger zone. I would say be very careful. Work with an employment attorney if you're considering this at all. It is discouraged, and both the IRS and the Department of Labor are enforcing and looking at employers who are misclassifying employees as independent contractors. It's a different kind of misclassification, not what we've been talking about today with exempt, non-exempt. But there's another big danger zone for employers where you classify your workers as independent contractors, and under the law, you can't just call anyone you want an independent contractor. There are very strict legal requirements for who qualifies as an independent contractor. And the tests are different under different laws. So there are, the IRS tests, for tax purposes, whether you can call someone an independent contractor or not. And then there's a separate test under the FLSA. There's even, different tests for discrimination laws, for benefit laws, under state workers' comp laws. The tests are all a little bit different. But, just calling someone an independent contractor, even if you put it in an agreement and you issue a 1099, that doesn't make them an independent contractor. For the FLSA test, it's kind of also referred to as the economic reality test. But the government would look at several factors to determine if the person is truly an independent contractor. And the fact that they were an employee and then they're converted to independent contractor would be suspect. One of the factors that determine if someone is truly an independent contractor for purposes of the FLSA is whether the work being performed is an integral part of the employer's business. And, that means, is it part of the production process or part of the service that the employer is in the business to provide? And if it was previously an employee, that answer is likely to be that it is an integral part of the employer's business. Another factor is the permanency of the worker's relationship with the employer. If someone is working for you for an indefinite period or an unspecified period, like an employee, even though they're at will, that is evidence of an employment relationship, not an independent contractor relationship. Another factor is the employer's control over the employment relationship. If the business controls how the job gets done and when the job gets done, as you would do with employees, that is evidence of an employment relationship, not an independent contractor relationship. Independent contractors typically can come and go. They just need to get the job done. The business doesn't control when and how it gets done. So that can be really dangerous. There's liability for misclassification. The liability could be, owing unemployment taxes, workers' comp benefits, health benefits. There are FMLA implications. You can't get around overtime if they're considered an employee in the eyes of the law. They are entitled to overtime even though you called them an independent contractor. So I would say to avoid that. Okay, I think we have time for one more question. Are we required to send out an employee communication, or is it just suggested? Can we just communicate with those few employees who might be affected by this change instead? And the answer is it is not a requirement for you to send out an employee communication about these changes. It is just a suggestion and just, as a best practice. And really, if you only have a couple of employees, it's sort of an isolated issue where not a lot of people in your business are affected, then I wouldn't suggest sending out a mass communication. The initial employee communication that we talked about is really for companies where there's already talk amongst your employees about this. There's unrest. There's rumors. People are asking. They've heard about it. Or if you have a large company where a lot of employees are going to be affected, it's just a good idea to put that out there as a heads up and to let them know that we are looking into who is directly affected, and we will follow up with you. You want to let them know this is a federal law. It's not a company initiative, and that like I said, anyone who is going to be affected in terms of their classification, exempt or non-exempt, will be followed up with directly. The only thing that is mandatory, which I mentioned in the presentation, is that some states do have mandatory notification requirements when you change an employee's basis of pay. So anytime you make changes to their compensation, if they're actually affected by this and you have to reclassify them as non-exempt, or if you choose to make any changes in payroll or someone's exempt or non-exempt status, in some states you do have to notify employees in writing of that. But that's different than the initial communication about this law change that we were discussing.
That's all the time we have for questions today. Thank you, Ashley. And if you are looking for more practical guidance on handling the overtime rule, visit www.complyright.com.